Consequences for breach of contract. Compensation for loser or damage caused by breach. Breach of contract occurs when a party either refuses or fails to perform his part of contract other than when such performance is excused under the law. There are various remedies available to an aggrieved party, of which damage are more frequently sought. Remedies for the breach of contract. Damage arising naturally, ordinary damage. When a contract has been broken, the party who suffer by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach. The general rule of measuring damages in case of breach of contract of sale is the difference between contract price and market at the date of breach. Damages in contemplation of parties, special damages. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss damage caused to him thereby, which is parties in knew when they made the contract to be likely to result from the breach of it. Remote of indirect loss. Such compensation is not to given for any remote and indirect loss or damage sustained by reason of the breach. There may be losses which clearly result from the defendant's breach of contract but are considered too remote from the breach for it to be fair. Expect the defendant to compensate the claimant for them. Damage in quasi contract when an obligation resembling those created by a contract has been incurred and has not been discharged. Any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default as if such person has contracted to discharge it and had broken his contract. It means the compensation for damage arising for breach of quasi contract shall be same as any other contract. Means of remedying the inconvenience. In estimating the loss or damage arising from a breach of contract, the means which existed for remedying the consequences caused by the non-performance of the contract must be taken to the account. It is the duty of the aggrieved party to take all reasonable steps to mitigate the loss caused by the breach and it cannot claim compensation for the loss. Party right compensation where penalty is stipulated. Basically, the parties to contract may stipulate at the time of its formation that on the breach of the contract by the either of them, a certain specified sum will be payable as damage. Such a sum may be or may not be the way of penalty. Penalty. A sum is the way of penalty when it extravagant and disproportionate to the damage likely to occur as a result of the breach. The court will award to party aggrieved only reasonable compensation not exceeding the amount named the penalty stipulate. Therefore, the amount fixed up at the time of the contract, regardless of the whether it is penalty or not, determines only the maximum limits of liability.